All right, this week's topic is civil rights, following up on our civil liberties lecture from last week. And to really approach democracy, most people agree that it's necessary to eliminate discrimination. And we can define discrimination as unequal treatment based upon race, ethnicity, gender, religion, lifestyle choice, all those different ways that we discriminate really ensures or prevents us from approaching true democracy. And the primary means for achieving equal treatment, in the United States at least, is to ensure full protection of what we call civil rights. These are the constitutionally guaranteed and protected rights that may not be removed from the government. And so remember, we said that civil rights refer to when the government must act. That is, the government must intrude on what people would otherwise do to make sure that all citizens are treated fairly. So the government had to interfere, had to act in order to ensure civil rights, for example, former slaves after the end of the Civil War. And that's what this picture is showing, is the voting for the first time that African Americans, former slaves, were able to vote in American elections. So again, the government must act, must intrude upon the acts of others to ensure that civil rights are guaranteed to all. And there are several groups within the United States population that have and continue to suffer from discrimination. And so here we have again the picture of the African American experience, and we'll talk a little bit about that, mostly in this part of the lecture. But there's other groups as well: Native Americans, Hispanic Americans, Asian Americans, women. There's additional groups that have been identified as a class that have been discriminated against: the elderly, the disabled, gays and lesbians. And so all these different individuals that make up one of these groups have suffered some form of discrimination by the government and other groups in America. So before we talk about the different moments in the history of the civil rights movement, for example, we're going to talk about what we mean by equality and discrimination. So here's the objectives for this part A, or part 1. We're going to have part 1A and part 1B. So we'll differentiate between discrimination and equality. They're really two sides of the same coin. And we'll talk about the African American experience in terms of inequality. And then after a break, we'll talk about the civil rights movement. Part 2 of the lectures for this week will deal with the inequality in America for the other minority groups that I mentioned. All right. When we think about civil rights, this is really talking about discrimination. And in order to ensure equality, you have to get rid of discrimination. And there's really two types of equality, two types of discrimination. The first is what is referred to as de jure discrimination. And this refers to before the law, the idea that there's either discrimination before the law or equality before the law. And in order for there to be de jure equality, that is, equality within the law, there has to be no legally mandated obstacles to equal treatment. Conversely, we can have de jure discrimination occur when that discrimination is based upon or the result of a law. So there used to be laws about segregation in this country in schools, and so that's an example of de jure discrimination, segregation in southern schools, segregation that was mandated by the law. Then there's something called de facto discrimination or de facto equality. And de facto equality says there is equality of results. And so this idea measures whether real-world obstacles to equal treatment exist. So de facto discrimination is that type of discrimination that's due to the consequences of social, economic, and or cultural conditions that might exist, probably induced by de jure discrimination. So for example, when we look at inner cities in America, there's an overwhelming number of minorities who live in the inner city, and that had to do with housing laws in the 40s, 50s, and 60s that prevented minorities from purchasing homes, for example, in the suburbs. Excuse me. So the de jure discrimination that occurred in the 1950s and 60s has led to de facto discrimination today. Okay. And so if we think about the number of minorities and where this trend is leading to in America, you can see this in the graph. that over time, by the time we get to 2050, the percentage of white Americans is going to be decreasing to about 50, a little over 50%. African Americans are going to be increasing, albeit very slowly. Asian Americans are probably about to double from 1990 to 2050, and it's the Hispanic population that is growing the fastest in terms of its relative population. And we can see that in this graph right there. All right, let's focus a little bit on the African American experience, and of course you have to talk about slavery. The Constitution of the United States, both explicitly as well as implicitly, protected the institution of slavery. So, for example, Article 1 talks about the legislative branch, and slaves are counted as 3/5 of a person for representation and taxation purposes. Also in Article 4, which we didn't talk about very much when we talked about the Constitution, it guarantees the return of escaped slaves. So why does the Constitution protect slavery? And the real reason is that slavery was embedded in this country before it was independent, particularly in southern states. And so in order to get the Constitution ratified, the framers compromised and allowed slavery to continue. And this legal status of slaves varied greatly in different regions of the country. So remember, this represents state-centered federalism, where states were running independently of federal overtures in terms of federal oversight. So there's a real difference between the theory of equality and the practice of equality during the Founding Fathers' time period. By 1804, many northern states had either banned slavery or passed laws under which the children of slaves would be free. But one point to remember here is that the Constitution originally protected the institution of slavery. But there was a balance, a very precarious balance in the Union between slave states and free states, one that when it was challenged, this balance would help send the country to civil war. And so we can think about the Missouri Compromise. And the Missouri Compromise occurred when Missouri, right here, wanted to enter the Union as a slave state. The Compromise admitted Missouri as a slave state along with the free state of Maine up here, so that there was a maintenance of the balance between slave states and free states, so that one didn't have more power in the Senate than the other. Slavery, according to the Missouri Compromise, was also going to be prohibited in the remainder of the Louisiana Purchase territory that was north of the Missouri's southern border. So you can see all this area up here is part of the Louisiana Purchase, and according to the Missouri Compromise, this was going to be free territory. However, with the Dred Scott case in 1857, if you will recall, we talked about this case when we talked about federalism, the Supreme Court basically declared part of the Missouri Compromise unconstitutional, since Congress can't deprive people of their property rights, and in this case slaves, under the Due Process Clause of the Fifth Amendment. So if you remember the Dred Scott case, Dred Scott was taken from a free state into a slave state and then into the territories that were free, so he claimed that he was a free man. But the Supreme Court ruled the Congress cannot declare this area free because it would deprive people of their property rights. All right. As we move toward the Civil War, you had during the war in 1863 Lincoln's Emancipation Proclamation. And basically what this said is that as these states seceded from the Union to form the Confederacy, President Lincoln said all the slaves that are living in these states, at least according to the Union, were thereby free. So it freed the slaves in succeeding states, not the slaves that were currently living in the northern part if they had not already been freed. Okay, so here we go down the path of at least trying to achieve equality for all during the Civil War, but we know it would be 100 years before we start to see real progress made. During the Civil War, or right after the Civil War, there are 3 amendments that are passed that collectively are called the Civil War Amendments, but they don't occur during the Civil War, just after. So the 13th Amendment declares all slaves to be freed. So Section 1 says, neither slavery nor involuntary servitude, except for punishment of a crime, shall exist within the United States or any place subject to their jurisdiction. So no slaves in the United States or any place subject to their jurisdiction. So the 13th Amendment is referred to or is thought of as the amendment that freed slaves. We've already talked a little bit about the 14th Amendment when we talked about civil liberties, the idea that there's due process and equal protection under the law, and this is how the Bill of Rights were applied to the states through selective incorporation. But the 14th Amendment also provided for citizenship for African Americans. So this is the kind of referred to as the Equality Amendment. So the 13th Amendment is the Freedom Amendment, the 14th Amendment is the Equality Amendment, and then the 15th Amendment is referred to as the Voting Amendment in 1870. And this gives the right to vote to anyone and should not be denied or abridged on the basis of race, color, or previous servitude. Notice the words race, color, or previous servitude. It doesn't say anything about gender. So ladies, we don't have the right to vote yet. That would come in the 20th century. So these three amendments together, freedom, equality, voting, these are referred to as the Civil Rights Amendment. It's during this time period as well that Congress passed what are collectively known as the Ku Klux Klan Acts of 1870 and 71. Also known as the Civil Rights Act of 1871. And basically it makes it a federal offense for two or more people to conspire to deprive citizens of their equal protection and voting rights. And it was aimed primarily at the Ku Klux Klan because it wanted to protect individuals, former slaves, as well as any other African Americans against intimidation by the actions of the KKK when the state could or would not provide protection. So if two or more people conspired to try and intimidate an African American from voting, for example, this act was supposed to protect that individual. So these actions that followed the Civil War seem to be designed to guarantee all citizens equality. However, this is also the era of dual federalism. Remember the layer cake federalism, where there's a real separation between the powers of the state and the powers of the federal government. So the Supreme Court did not enforce most of these laws. And remember when we talked about selective incorporation, it took well into the 20th century for many of the Bill of Rights to be incorporated into the states. So it would take many more years for the 13th and 14th and 15th Amendment to be applied to the states. So the Supreme Court upheld the states' rights to treat its citizens as they chose. And so Jim Crow laws were passed in southern states in particular to circumvent these amendments that guaranteed freedom, equality, and voting to African Americans. So here are some examples. And again, the dual federalism led to these Jim Crow laws. So there's laws passed in the state of Georgia segregating schools and trains and parks and baseball fields. And in South Carolina, separation of railroad cars for blacks, segregated work areas. The city of Baltimore in Maryland established separate living districts for blacks in 1910. So this is an example of a de jure discriminatory law. De jure discrimination, remember, says that there is a law in place that discriminates. But even after this law is overturned, you still have separate living districts for minorities and whites because of the fact that they were separated before. So now we have de facto discrimination based upon the fact that there are obstacles to segregation. Obstacles to desegregation. Okay. Louisiana had examples of Jim Crow laws, Oklahoma, Mississippi, and these are just a few examples. So if we think about Jim Crow laws, okay, this is out of place, but we'll get to that in a minute. That's okay. Jim Crow laws, just kind of in general, there were property qualifications. Since many freed slaves really didn't own any land, these type of property qualifications would keep them from voting. So many states passed laws that said you have to own property to vote. There's also some literacy tests, so it would keep people who did not know how to read from voting. But the states also found some loopholes so that they could include poor whites in voting while excluding African Americans. So they would have what's called an understanding clause. People were permitted to vote only if they could properly interpret a portion of the state constitution, for example. There was also something called a poll tax, a fee for voting that was used to exclude poor African Americans. But all three of these also excluded poor whites. And so to get around this issue, the white primary was put into place. And the party in the South, at this point in time, it's just the Democratic Party. There's no Republican Party in the South right after the Civil War. Used a whites-only primary to select the Democratic candidate, making African American votes in the general election irrelevant. Okay. Well, what was the Supreme Court doing? Remember, this is the era of dual federalism, so Congress has no real constitutional authority to really act. So the Supreme Court starts to get into action. And this is exemplified by the Plessy v. Ferguson case. And this is where the Supreme Court ruled that segregation did not violate the 14th Amendment as long as each race is treated equally. So this ruling sets the precedent for separate but equal. So when you see Plessy v. Ferguson, you should understand that this is the Supreme Court action that set off the legalization of segregation in this country. As long as, at least this was the ruling, as long as there was equality, there could be separation. Okay. In 1909, W.B. Du Bois, who was the first African American to earn a Ph.D. from Harvard, and other African Americans, as well as whites, formed the National Association for the Advancement of Colored People, the NAACP, and the role of the NAACP is to litigate on behalf of racial equality. So they convinced the court in a series of cases to start looking at these different state laws that discriminated. They wanted the court to deal with de jure discrimination. And so obviously the big case that reverses the Plessy case is the Brown versus the Board of Education. Okay. So these two court cases should be thought of together. Plessy v. Ferguson sets up separate but equal. As long as facilities are equal, they can be separate. Plessy is overturned 60 years later in the Brown versus the Board of Education case. So Plessy establishes the idea of separate so long as the facilities were equal, but the Supreme Court began to look more broadly at the idea of equality, not just in terms of facilities, but also in terms of the psychological effects of segregation. A psychologist, Kenneth Clark, published a study where he found that African American school children who were shown white and black dolls and asked which one they preferred, they invariably chose the white doll, showing that there's a psychological effect of segregation. And so that would lead Thurgood Marshall, that this gentleman right here is a very tall man. He later becomes the first African American Supreme Court justice. So here's Thurgood Marshall as a young man, and here is Thurgood Marshall as a Supreme Court justice. He lived from 1908 to 1993, and he's on the Supreme Court from 1967 to 1991. But as a young lawyer, he represents the NAACP, and he represents Linda Brown in the Brown versus the Board of Education. He's here with Arthur Shores, as this gentleman on the right, and Autherine Lucy. They are both civil rights activists. Okay. And Marshall argued that segregation had a devastating effect on African American children's self-esteem, and therefore the education in separate educational facilities could never be equal. And so in Brown, who agreed with Thurgood Marshall's arguments, ruled that the separate was inherently unequal and that desegregation should proceed with all deliberate speed. So these are two very important court cases, and they're really usually referred to as a set. So Plessy v. Ferguson establishes segregation through the separate but equal phrase, and the Brown versus the Board of Education comes and overturns the Plessy case and says separate is not equal. In fact, it's inherently unequal, and desegregation must proceed with all deliberate speed. Well, the Supreme Court doesn't have a police force, and so everyone interpreted this deliberate speed differently. Okay, but Brown is important for two reasons. It signals the end of segregation, at least in terms of the Supreme Court. But more importantly, it signals to the national government that they had the power to intervene in the civil rights area. So the enforcement of Brown, when states were told to desegregate, they didn't just automatically do it. It was met with resistance and would take years. And so you had this massive resistance was realized when you had legislatures in several states pass laws ordering school districts to maintain segregated schools. So even though you have the Supreme Court of the United States say that schools had to desegregate based on their ruling in the Brown case, individual states passed laws ordering the school district to maintain the segregation. In some cases, this massive resistance to desegregation involved closing the local public schools and opening, quote, private schools for white children. And of course, one of the most dramatic instances of massive resistance was in Little Rock at Central High School, where Governor Faubus mobilized the Arkansas National Guard to prevent the integration of schools. And it required President Eisenhower to send in federal troops and place the city under martial law to desegregate the schools in Arkansas. All right, but those are the things that are going to lead to the civil rights movement. And so you start to see equality and the denial of the United States, in the United States, of any type of discrimination based on whether it's race or, in this case, women marching. You start to see the advent of the civil rights movement. And that's what we'll talk about after the